Avalon.
Good morning, sir.
Sir, you were in February charged with terroristic threat of a family or household member. It's come to my attention that you have now picked up a violation of a bond condition or a protective order. I have no idea what happened, but I want to find out. You have the right to remain silent. Anything you say can or will be used against you.
Well,
Not you. That. You have the right to remain silent. Exercise that.
On March 29, 2025, law enforcement officers were on patrol when they observed a white Honda Accord driving south on a public city street located in Harris County. The law enforcement officer ran the vehicle's license plate through NTIC and observed their emergency equipment and followed the defendant's vehicle that drove into a gas station parking lot and pulled over to stop. The law enforcement officer approached the defendant's vehicle and observed the passenger sitting in the front seat wearing a seatbelt. The defendant requested the full name and date of birth of the passenger, who identified herself as Stephanie Avalar, and that was confirmed by the law enforcement officers. The law enforcement officer also found that that her name came back as a protected person from a recent violence incident, and ran the identifying information of the driver, also known as the defendant, that came back under the same protective order as the defendant for that case as well. The law enforcement officers reapproached the vehicle and detained the defendant, and confirmed that one of the law conditions and the protective order was the defendant shall have no contact with the
So it's just the by virtue of the, so we had issued the no contact, right?
Yes, Judge.
All right, so Mr. Avilar, I'm going to find that there's sufficient probable cause to go forward. You have to understand that when we have court orders, we mean it. It's not hard. You have a lawyer. When you want something changed, you talk to the lawyer. The lawyer can come to us and we hear things out and we can change things. But when you try to do stuff on your own, everything goes sideways, and it goes sideways quick, as you now know. So,
in Your Honor, we will be, would like to approach off docket tomorrow to try to have the MOAP amended. The state did in fact try to call the CW, but they have not been able to speak with her to clarify that she would in fact like him to be able to come home and have contact and the like.
So what happened?
Terrorism threat. He appeared in peace court on February 13th. He received a PR bond, and next week he came in here for an arraignment. He appeared. He got a reset for April 23rd.
Right, but I'm showing now he's bond active after the new case. Why? Did they give him another PR bond?
No, this case was never.
Look, it shows bond made on the terroristic threat.
That's from the previous PR bond. He was never revoked after since the new case. This case has still been on bond.
Did they not address it? And I'm at a loss if they never addressed it.
Yes.
It was a new court. His only reset is for April 23rd.
Mr. Woodward, my concern is that, they gave them a PR bond on the terroristic threat. I don't even show that a PR bond was given. Oh, here we go. On 2/13, now he's picked up a violation of protective order. So I can't continue to give you a PR bond when you're picking up new cases, man.
Can I speak? Can I ask? It's because I made bond.
No.
Sorry.
You need to talk to your lawyer before you talk to me, because I don't want you to say something that hurts your case.
Sir.
I'll give you time to talk to him, but I can't. We do things a certain way. You can't do stuff on your own. You've been through the system long enough to know that.
Yes, sir.
Are you on parole at this time?
Oh, sir, I'm not on parole, but I paid for my bond.
Hold on. So no PR bond on the terroristic threat. Okay. Let's do this. Your lawyer said he can be here tomorrow. So we'll have him come here tomorrow so he can talk to you and you guys can regroup, try to figure something out. So Mr. Woodward, you say you can be here tomorrow?
Absolutely.
You want to address it, I guess, then?
Yes.
Okay. So we'll roll you to tomorrow. We'll try to figure something out.
Judge, he's supposed to get released today because of the surety bond on the BPO.
Rep, I'm not giving him another PR bond when he picked up a VPO though.
Do you want me to revoke
The
the?
PR bond. Yeah,
No,
Your Honor,
yeah.
I mean, I certainly understand how you work, but since I'm not there with my client, I just like for him to experience that. The facts of the underlying case, Your Honor, are that, he and the CW, they're in a relationship, they had an argument. She grabbed his hair first, was pulling him, then he was grabbing her, but a text message was sent from an unknown number saying, if you don't come home, I'm gonna fuck you up. Excuse my English, Your Honor, but that's what was the crux of the PC, Your Honor.
Of which one?
For the terroristic threat case.
I don't know. I guess what happened in the terrorist threat?
Yes, Your Honor, if I just have one moment.
My understanding is that the CW is willing to communicate, that there was a little bit of a misunderstanding of the facts. I believe the state called her once. She said she wasn't available, but she would be if they called back. I don't think that she's been able to communicate that there was a little bit of a misunderstanding of the facts.
Your Honor, what I have is that this was from, the threat was made during an altercation where the defendant told the complaining witness, and I quote here, I apologize for the language.
Don't be shy. Come
Yes,
on.
Your Honor,
We all know the F word.
I'm going to fuck you up if you don't come home.
I understand that made during an altercation, Your
If you
Honor.
don't come home. It was made during, the defendant admitted that there was an altercation, admitted that he told the complaining witness, I'm going to fuck you up if you don't come home.
Your Honor, I'm looking right at the summary of facts. It literally says, on her cell phone contacts, complainant stated the defendant then began to threaten her via cell phone text, which he stated, I'm gonna go kick your door. I got you. I'm gonna fucking kill you. Complainant stated she was fearful for her safety. But before that line, it says it came from an unknown number. It says it in the summary.
Your Honor, it is further down in the summary of facts that there is an admission.
I mean, of course, Mr. Woodward, someone can make something from an unknown number, but they can corroborate it at the same time, And I think that that's
Yes.
what the state is saying here, that he corroborates the actual text message saying that I'm going to go fuck you up. Right?
Yes, Your Honor.
Yes.
The problem is that we have him, he's still doing stuff on his own. I've told him not to do it, admonished him not to do it, and he's still,
Yes, sir.
in this life, when you do things the right way, good things happen. When you do stuff the way you want to do it in violation of orders, and you've been through this sufficient that No, it's not the end of the world, but how do I get your attention so that you realize that we mean business? If I just give you PR bond after PR bond after PR bond, we have no teeth.
yes, sir. I paid out of my pocket to get bonded. They gave me a bond downstairs and I paid
When
for it.
you're on your VPO, but I'm not going to give you a PR bond when you're picking up a VPO.
She called me, her home had it.
I'm not going to, no.
Alright.
Like I said, talk to your lawyer first. Start telling us stuff, because I don't want you to put
Yes,
yourself
sir.
in your mouth when you think you're trying to help regardless. Now, look, we can come back tomorrow. He's going to come here. We can try to work something out. But
I was just trying to help, sir. I've been staying away from her. I got like 10 days left.
Sir, I got you. I'll come check up on you, okay?
back tomorrow, we'll deal with it and we'll figure something out. So you'll definitely be here tomorrow, Mr. Woodward?
Absolutely, Your Honor.
Okay, so I'm gonna revoke it for now. Come back tomorrow. We'll talk. Do you have a place so they can reach out to the complaining witness so they can get a rip done by tomorrow, Mr. Woodward?
I do not have it readily available, Your Honor. I can likely get it.
Okay, so can you try to do a rip between now and tomorrow so we can try to figure out what she wants and then we'll go forward, please? Okay, all right, we'll see you tomorrow.
Thank you, Your Honor.
All right, bud. We'll see. Good morning, Ms. Stews. Ma'am, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On March 18th, 2025, at 5:21 p.m., an officer was dispatched to a theft at Walmart with a female in custody. Upon arrival, the officer took custody of the female.
Good morning, Mr. Avalon. You were charged in February with making a terroristic threat to a family or household member. That charge alone is serious. But now something worse has come to light. The court has learned you may have violated a bond condition or a protective order. The judge admits he doesn't know what happened yet, but he wants to find out. You are told you have the right to remain silent. Anything you say can and will be used against you. Not for you. Against you. The judge repeats the warning. Then he adds something unexpected. Exercise that right.
Thank you. Ms. Dews, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to go to any Walmart for any reason whatsoever. If I find that you do, I will revoke your bond, put you in jail, and no more PR bonds for you. Do you understand?
Yes, sir.
Likewise, if I find that you pick up any new cases, your bond will be revoked, you will go into custody, ma'am. Do you have the ability to hire a lawyer? Okay, I will have you fill out an application. Deputy Miranda is going to give you an application. I'm going to have you sign a reset with Victoria. After that, we'll have you take a seat in the jury box while we get your bond conditions ready. Do not leave until you sign them. Okay? Please. Do you mind filing those? No going to any Walmart?
Yes, Your Honor.
Anywhere.
No Walmarts anywhere.
Anywhere.
Thank you, Your Honor.
Frank Reyes.
Yes, sir.
Mr. Reyes, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Simply. Okay.
Officer was dispatched to a minor crash in Harris County, Texas, where the defendant had rear-ended the complaining witness. Upon contact, the officer found the defendant in the driver's seat, slipping in and out of consciousness. When the officer woke the defendant up, the defendant attempted to start his car and drive away, but at that point, officers had his keys. The officers did not notice any injuries on the defendant. When the defendant exited the car, he was unsteady, and officers observed and uttered alcoholic beverages, bloodshot eyes, and slurred speech. The defendant admitted to drinking at a bar earlier. Standardized foot sobriety tests were conducted, and the officers observed 6 out of 6 on the HGN, 8 out of 8 on the walk and turn, and 4 out of 4 on the one-leg stand. While en route to the Joint Processing Center, the defendant fell asleep in the officer's vehicle. At the Joint Processing Center, officer read the DIC and defendant consented. However, the defendant fell asleep again and began vomiting. The defendant was transported to the hospital, and a blood warrant was signed and executed.
So no breath test was done.
No, Your Honor.
Please see if there's a valid license.
Yes, Your Honor.
Mr. Reyes, I'm going to find that there's sufficient probable cause to go forward with your case. You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. If you do not, I'm going to give you a portable device. You're not allowed to drive any vehicle from now on that's not equipped with an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock on it, I'm going to put you in jail and I'm going to make your bond high. Do you understand?
I understand.
It says ineligible, Your Honor.
You are not allowed to drive. You will be signing an affidavit with me today promising you're not going to drive. Mr. Reyes, heed this warning. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you get into a car and drive. Do you understand?
I understand.
You cannot justify driving for any reason. I don't care if there's a burning building and you have to save 50 babies. Do you understand? I'm sending notice now to DPS so that every single officer in the state knows that you are not allowed to drive a vehicle that doesn't have an interlock. If you're caught driving a vehicle, it doesn't have an interlock, they will arrest you and put you in jail. I am now giving you a portable device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol. You will also be tested for illegal drugs as well. You test positive, you consume alcohol, into jail you will go. Do you have the ability to hire lawyers, sir?
I do.
We're going to give you time. I'm going to have you come up here, swear to us that you're not going to drive. I'll get you to Victoria. We'll have you sign a reset. You will get with Fleischer for your bond conditions, and after that, you're free to go.
Please come from that you can.
Good morning, Mr. Sullivan. Sir, you were charged with assault with a family member. You're facing up to a year in jail and a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. On March 23rd, 2025, at approximately 15:39 hours, the law enforcement officer was dispatched to an address in Harris County, Texas. In reference to a discovery. The law enforcement arrived on scene. They made contact with the witness, who stated that her husband, the defendant, had been arguing because her adult daughter does not like the defendant and asked the complaining witness to pick between having a relationship with her and her grandchildren or the defendant. The complaining witness stated she decided to sever a relationship with her daughter and informed the defendant that she would be moving back to Arizona. The complainant was stated this upset the defendant and he began arguing with her. She then expressed that she hated him and this made the defendant more upset and he told her to hit him if she hated him so much. The complainant was stated she hit Mr. Sullivan with a closed fist on the head and face area 3 times before losing balance, slipping and falling. This fall caused her to hit her face on their bedroom dresser. The complainant was then said she got up and crawled into bed and she was laying on the furthest corner of the bed closest to the wall and covered her body with a blanket. The complainant witness stated that approximately 10 minutes went by. Mr. Sullivan, the defendant, continued to argue with her. He crawled on bed, grabbed her, flipped her over, for her back was on the mattress, and used his body weight on top of her while placing both hands on her upper arms to hold her down. The complainant was stated this caused her pain, and she was able to free one of her arms and use her hand to grab the defendant's genital area and making him let go of her completely. The defendant then used his right hand and punched the complaining witness on her mouth, causing pain and visible injury. The complaining witness added the fight then diminished, the law enforcement officer observed visible injuries, including large purple bruises on both arms and injuries to the top and bottom inner lip.
Laser, you hearing this?
Yes, Your Honor.
Interesting. So she's the initial aggressor though, correct?
Your Honor,
So it looks like he says, hey, hit me, antagonizing. She gets into it. She pops him, what, 3 times in the mouth, you say?
Yes, Your Honor.
Don't say anything. Sorry.
So, Your Honor, only thing I would ask is, this is not home court's case. If we can just stand down, wait for the DVD prosecutor to be here. I don't know if he's spoken with the complainant yet, if he has anything more to add. I would just ask the court to withhold the finding until we can get the prosecutor to go.
All right, Mr. Sullivan, just do me a favor. Will you just take a seat behind the jury box? I'm going to get, I'm going to also appoint him a lawyer, if you don't mind. I'm going to appoint him someone as well so we can do just.
That's totally fine, Your Honor. Let me, and I'll email DVDs.
Okay, all right.
Thank you.
Do me a favor, just take a seat for me real quick, all right?
All right, Judge, next is.
You're Abner Guzman.
Guzman.
Sí.
Yes.
Mr. Guzman, you're
Señor
charged with
Guzman,
displaying a
acusado
fictitious license plate,
Con red placas.
6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed for you.
Thank you. On March 24th, 2025, at around 11:20 a.m., officers were dispatched to a B&B call at 2520 Airline Drive in Harris County, Texas. Upon arrival, officers observed the defendant's vehicle parked in the west side parking lot near the fence of the
Houston Farmers Market.
with the front passenger window
Con
broken.
la ventanilla del pasajero del frente quebrada.
Officers conducted a vehicle check
Registro vehículo
on the temp license
en
plate
la licencia de manejar temporal.
and returned it
Pero
without
la
match
placa. Y regresó, lo tenía ahí,
the defendant's vehicle.
del acusado, el vehículo del acusado.
At 12
A
p.m.,
las 12 p.m.
the defendant arrived
el
on
acusado
scene,
llegó.
told officers that he was the owner of the vehicle.
Era el dueño del vehículo.
Defendant was
El
detained.
acusado fue detenido.
Defendant said he had purchased the
Él
vehicle
compró el vehículo
5 years prior
5 años anterior
in Florida
en la Florida.
and paid an additional fee for the seller
Costas adicionales al vendedor
to change the title
para que le
to the name.
cambiaran título,
But the seller did not do that.
pero el vendedor no lo hizo.
Defendant stated he met a
El
woman
acusado declaró que él conoció a una mujer
on WhatsApp
en WhatsApp
who offered him a
que
fake
le
temporary license
ofreció
plate
una placa falsa temporal
for $40,
por $40
which he purchased.
que él compró.
Defendant stated he had been driving the
Dijo que había
vehicle
estado manejando el vehículo
with fake temporary
con
license
las
plate
placas temporales falsas
for 4 years.
por 4 años.
The defendant was
El
ID'd by his
acusado fue
Guatemalan.
identificado por el pasaporte de Guatemala.
Mr. Guzman, I'm going to find that there's sufficient.
The courtroom goes silent. March 29th, 2025. Harris County, Texas. Law enforcement officers are on routine patrol. They observe a white Honda Accord driving south on a public city street. Nothing looks unusual at first. An officer runs the license plate through the system. Something immediately flags. Emergency lights activate. The Honda keeps moving. It turns into a gas station parking lot. The vehicle finally stops. Was the bond just violated? Did this one stop change everything? One decision. One moment. One case on the edge of collapse.
Status is. But if you're not in this country with permission and you go to jail,
A la cárcel,
and immigration finds you, they will put a detainer on you and you will be stuck like Chuck in there until this case is over with,
caso se
and then you
acabe.
get shipped off to immigration.
Yo,
Do you understand?
¿entiende?
Sí, sí.
Yes.
Do not.
No maneje.
This is the only bond condition that you have. Do not pick up any new cases as well. If I find that you're a danger to my community, likewise, I will put you in jail.
Igualmente no.
You have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with him. If he tells me that he cannot get a hold of you because you're playing games, you're not responding to phone calls, text messages, likewise, I will revoke your bond. Do you understand?
Él lo entiende. Yes.
Okay. I'll have you sign a receipt of Victoria. We'll have you swear to us that you're not going to drive, and after that, you're free to go.
Thank you, Judge. Maybe excuse me. Thank you.
Yeah, take care. Hey,
Aaron Durden, bond violation report. You said bring him today. He's here.
come up, Mr. Durden. We're here on yet another bond violation report. It is now alleged that the client was instructed to install an ignition interlock device, not to tamper with the device, to blow into it. And from 2/20 to 3/20/25, you skipped 8 tests, not using the device as instructed.
I'll explain, Judge.
Please.
All those violations except one are on the same day. If you look at the photos, there's only one person in any of the photos. It's not him. He owns a company. He allowed his employees to drive the truck. They didn't understand the deal. All the other pictures show nobody in the truck. What they did, they're roofers. They just left the truck running while they were doing work to keep the climate control on. He has since clarified that. We've emailed pretrial last week asking them to try to get the photos before the violation so we could see who was actually driving the truck, but we didn't hear any response.
He has guys, does he have a blow schedule that he's supposed to blow? He has a blow schedule. He's supposed to blow at certain times and he's not blowing.
Are you not blowing at certain times?
That's not, no, that's not true, Your Honor.
I have here 8 skip tests.
No. So one of my guys was driving the truck and he did not, I didn't instruct him that when you stop the vehicle, that you can't just leave it running. So he wasn't informed about that. So he just left the truck.
But it was rolling retests that were skipped. That's the allegation, rolling retests. So somebody started the truck, got out of the truck and left it running, and it just kept saying blow, blow, blow. If you look at the times and date, they're like 5 minutes apart for 15 or 20 minutes.
Yes, Judge, I do see that it's the rolling retest. As far as what specifically that entails, honestly, that's something I haven't encountered before.
I haven't either, but bottom line, he's supposed to test at certain times.
Yes, but that would be a missing test, but the allegation is in the bond violation, rolling retest.
So yes, there's no violation, no allegation that he has missed his flow schedule.
What times, do you have this time set that he's supposed to actually blow?
I can reach out to the manager and get that information.
Do you mind? I'd like to know what specific times is he supposed to test?
Yes.
And did he actually do it on that times, or is it someone else blowing? That's what I'd like. So let me see what they say and then we'll come back.
I have any big problems today.
Something nice.
All I need is a reset for 45 days. The prosecution and I have come to an agreement. Christian Willis. The prosecution and I have come to an agreement as to the resolution of this case. He just needs about 30 days in order to.
It's nearly 200 days now. What do you, what did they offer? What did they offer?
We've offered a PTI now, Your Honor.
And what did,
So I forfeiture the weapon and gun safety class and a drug and alcohol awareness class, I believe. And a drug awareness class, I believe.
so I'm gonna give him 2 weeks to get the stuff
2
done.
weeks?
Yeah, it shouldn't take that long. It's a gun safety class, it's probably 2 hours.
Yes, yes,
And then
yes.
the other class also is just a couple hours.
So
So
we need 3 weeks instead of 2? Because I still have balance. 3 weeks. 3 weeks. Thank you,
Mr.
sir.
Willis, where's Mr. Willis? Come up.
This is the first time ever getting in a.
Mr. Willis, he has secured you an amazing deal where if you do 2 simple classes, both of your cases will get dismissed. If you do not have if you don't have them done in 3 weeks, I'm not going to take anything else. I will immediately set your case for trial. Do you understand? There's no excuse why you can't get both classes done in 3 weeks. All right, Mr. Cashin.
Thank you, sir.
See you.
See you next time.
Take care. Hey,
Judge, we're here on Mr. Aziz. Newly retained on the case, Judge. Newly retained on the case.
oh, you retained?
Yes.
Got it. Okay, so come on up. We were waiting because he said that he hired a lawyer. We were waiting to see him. Come on up, Judge. So have we done PC on this case yet?
Judge, he was THA. They just had to sign on.
Okay, so we have here, do you mind doing me a favor? Can you run his license to see if he has a license? This is a failure to stop and give him information.
Yes, sir.
Leaving the scene of an accident. So I just want to make sure that if you're going to drive, that you have a valid Texas driver license and liability insurance. If you do, then you may continue to drive. If you don't, then I'm making it a bond condition that you not drive until you have both of those things.
Yes, Judge.
Yeah, disagree with fitness eligible.
Okay, you do not have a Texas driver license.
I have a California driver's license. I was stationed in California. I'm a veteran.
Is it eligible?
It does say eligible, Your Honor.
Okay. All right, so one of your other bond conditions is you are not allowed to drive unless you have liability insurance in your name. That is a bond condition. If I find that you drive without car insurance, because all I'm asking you to do is follow the law. If I find that you don't, then I'm going to put you in jail. You understand? Great. You've got a lawyer. Because you have a lawyer, we will waive your appearance. So you don't have to waste your time coming to court, but you must stay in touch with them. They'll tell you if and when you have to come back to court.
Quick question. Do I just need to come back with like my insurance and give it to them so that they know that it's valid?
Yeah, just let them know, then they can show it to us so that we can verify it and then you're good to go. But like I said, I'm waiving your appearance. You don't have to waste your time coming to court, but just stay in touch with them and they'll tell you. If they tell me they can't get a hold of you because you're gone, then I will issue a warrant for arrest. You don't pick up any new cases. Got it? We're good.
Thank you.
Thanks, Judge.
So don't leave until you sign the conditions and then after that, you're free to go. So D, file no driving without a valid license and liability insurance.
Yes, Your Honor.
Thank you, Your Honor.
Guys, have fun.
Urging on Jasmine Tovar Martinez, Judge. She had a BVR. On Friday, she came to court. She was sent to go get drug tested and it's negative. She is present. Martinez had a cause of mercy like that. That's it. That's the one.
Judge, it's 254.
8319.
I think just.
Ms. Tovar, come up. Did we put a scram on
I
her?
believe that's what happened. I wasn't here on Friday. Was she good? Scroll.
Do you mind checking?
Yes, scram device not Friday.
That's positive again. It's not going to go well for you. You better know every single thing that you put in your body before you do. If I see that you have a positive and you try to tell me it's mouthwash, it's a tequila lollipop, it's hair dye, I don't care. No more excuses. You understand? Okay? All right.
Thank you, Judge.
Yes, sir.
Okay, have a seat. Give me 1 second.
Who's the guy that took in? Work to you?
Oh, James.
Almost all the letters? No, I don't need it. No.
So 30,006
30,000?
and six. No, maybe I'll make it higher.
What do you think? No, they didn't say it's Lindsay Ball. Oh, I didn't know. I let them know. Okay. Did you hear that? Yes. State needs. File the bond. You need one.